Good afternoon. Good afternoon, all. Very nice to see you. All please don't take it as your valuable Sunday. Sunday is all day and it is for that family time. Even I myself believe it, because even doctors say that all 6 days should be alike and 1 day should be to yourself or family. That is why, in fact, even working days have been brought to 5, only 5 days a week, 6 on Saturday. High Court Supreme never work on Saturday. Lower Court works some states first and third Saturday. So it's an interaction. I'm grateful to, first of all, Advocate Keshav Sharma. It is his initiation. It is his site. It is his desire to expand the knowledge of law to all incoming advocates, law students, practicing advocates. My dear friends, one thing is very certain, that nobody can say I am learned. We have been learning and we continue to learn, and we will also learn in future. Learning is an unending pursuit of knowledge. As in medical field, in engineering field, in other fields, this legal field also having so many branches in itself. For example, constitution matters, then the trial matters, suits, civil matters, criminal matters, consumer matters, accident tribunal matters. Now added to is DRT, Debt Revenue Tribunal, NCLT, company law matters. Then IBS. So it is expanding, but it is not reducing. So coming to the topic of the day today, which I believe you all agree that it is the heart and soul of pleadings. The heart and soul. Only a mother can understand what child requires. When a child cannot speak, the child will only cry. Mother says, yes, he or she is hungry. This is a communication. So please make a mental note of it, because you are all learned, I'll say that. Law student means either graduates plus law or 12 plus law. So you are undergraduates and are graduates who are going to be in the field or already in the field of law. Only one word, keep it in your mind. My dear participants, communication. Communication is the only the base for so communication has to be has to be. I'll go in detail. To the point, in simple language, are consistent, precise, and easily communicable. That is to be understood by both parties. There are always two parties in any litigation. The first party, either they'll put his grievance or what relief they are seeking, that And if it is a police case, the police will try to get preliminary custody of 14 days. Police custody cannot be more than 14 days, and then plus judicial custody. And the other side would like to come out on bail, get released on bail, pointing out. Police try to prove their case. So drafting is it. That is a charge sheet. That is why the what charge you make, what offense is committed, how you convey it, what losses. So in all respects, and in suppose for example you take matrimonial petitions, in matrimonial petition the pleadings become the heart and soul of the matter, saying that whether there are one thing. One is asking for restitution, restitution of conjugal rights. Means any spouse asking the other spouse who's away to again come back and join the family, matrimonial family, or for divorce. Even for divorce, divorce again, section 13 Indian that where is the ground cruelty is there, what the desertion is there. There is a minimum 2 years should be separated. So all this how to be conveyed. So that is in mind. Kindly see what is the drafting. Before I proceed to the actual drafting pleading, this is just a beginning. Dr. Sarvepalli Radhakrishnan has clearly said the law is such. Law, in other words, let us understand pleadings. It is bigger than kings of kings. Why? Even the kings have to come under rule of law. Like Professor Hebb said, the group of wolves, Aina, are much better than group of men unless they are governed by a rule of law. Why? Because of intention to get better than the neighbor. And there is a always, yeah, there is always in intention to get better than anybody. There are only two things. As a practicing advocate or students will come to know, even in ordinary life, there is a need and greed is different. Need is a requirement, necessity, compulsory. Greed is something, lalach, aur jyada kaun. So only this is the difference. So pleading, Dr. Sarvepalli Radhakrishnan said, king, it is a kings of kings. It is only rule of law. That is why this is the only profession. Kindly understand, it's the only profession which is equated with divinity, justice. Equated with divinity, only one profession. That is why my lord, my lordship, this word, there is no, you don't go to any doctor and say my lord. It's only in legal terminology, this is there. So why this is there? Because equanimous, that you must have a scale. That is, the justice is yatho dharmasta tato jayaha. Where dharma means not religion, my friend. Yet dharma is righteous conduct, truth. That's all. As per truth, a judge has to give judgment after hearing both sides without fear or favor. So coming to the drafting, what is the concept? Drafting means to draw, to write, to sum up. Pleading means to plead, to place before the necessary points. Now please note that qualities of good drafting or writing. I'm not going to elaborate. It's the interactive sessions. Conciseness. As a conciseness, be very, very, very precise. Point number one. I have sent a small note to Mr. Keshore. You can take copy from him. This is available, small notes. Then second is clarity. Clarity means what is to be informed to the other side first, to the judge, and how clearly you communicate. The third point is I try to put all in C, completeness. Complete means you write a letter, you write a petition, what you are starting for, it should be clarified and it should be like it should complete that what you want. Sometimes we come across in the beginning I also experienced, I have not learned that my prayers are not proper. So a good judge is there, a liberal judge will give, Mr. Advocate, your prayer, please amend it. We give you liberty to amend the prayers. What you are saying in the petition, what your prayers are, two different things. So it should be what. So that is completeness is you must ask what you are asking for. What you ask is what your client wants, what your client wants from the court. Then the fourth point is preciseness. This is where I am going to express my bit regret that in our, especially in India, in my PhD, I have done comparative study of world all courts. In Japan, they don't give more than 15 minutes. The preciseness, why I'm telling, I have seen myself in High Court. They keep on repeating same thing. Keep on repeating. Why repetition? You are given your point then. In Japan system, they give only 15 minutes. There's no 16 minutes. Then you say, okay, where is the fairness of opportunity, principles of natural justice? So they say that, yes, we can't give you more time. After 16, 15 minutes, please sit down. Whatever you want additional, if you cannot sum up in 15 minutes, please give us in writing. We'll accommodate. We'll read and we'll pass the judgment. So preciseness. One example I'll give you. Before parting this, quality of good drafting in legal terminology, in ordinary English writing, what you write, only you remember CCC, triple CP. That's all. Triple CP. This you can easily remember. You don't need any notes. Triple C meaning first C means conciseness, second is clarity, third is completeness, fourth is preciseness. To be precise. So please remember this, all of you, my friend. CCCP for good drafting error. The example I am going to do, I was fortunate enough to participate in one felicitation function of a incoming new judge, Mr. Gadkari. He was a public appointed as a judge, where Justice Oak was invited. While delivering a small speech, he showed his anguishness of that is why clarity, completeness, preciseness, especially. He says, my dear advocate friend, please kindly remember how a judge functions. In one matter, he said, I'm not taking the names, not necessary, because I don't want to give any bad feeling to anybody. All are equal, all are capable. So all are good. The one side has given 42 judgments, argued for a couple of days. So not to lessen and to prove to his client and to also further his client's ultimate goal, the other side quoted 47 judgments and argument, then written arguments. So Justice was very openly expressing his feeling as a High Court judge, how much work I get when I have to read these 42 judges and comment on it. When I read that 47 judges, 47 and 42, 89 judgments, that to some of the voluminous judgment, how I'll bring in ratio, how I'll link with these facts, and then give a conclusion. This is the example of non being precise, non being conciseness, not being clarity, not being complete. To furtherance this topic, the Chief Justice, present Chief Justice, Honorable Justice Mr. N.V. Ramana, time and again is telling, is trying to improve the judiciary. We have a very good now workable and with some ideas to improve the judiciary. He is telling be precise, be concise, speaking orders. He says even at the stage of bail in criminal law, don't go into the merits and demerits of whether offense can be proved or not. What is there? Only whether offense, whether is available for trial. He will not jump the bail. He will not tamper with the evidence. That's all. Fourth, there is nothing other ground to be precise. And whether is a mokoka, what is available, non-available offense. In certain cases, that there is a restriction. In NDPC section 37, no bail can be granted. So there is a bar from the legislature itself. So, my dear friend, let us be very concise to save the time, but at the same time, clarity should be there. Now, the second part. So please remember triple CP for drafting or writing. Then the second point I want to canvass is this Mr. Pisse and Gilchrist, they have propounded some rules of drafting pleadings. What they say is a draftman, a writer should have a complete design. For example, like if a builder wants to construct a building, he has needs to appoint architect. Architect gives the plan from basement to the terrace, upper floor, with all its necessities, how it can. So compulsorily a draftsman should conceive the whole design of what is, whether it is a bail petition, whether it is a maintenance petition, whether it is a simple application for exemption, whether it is a application cancellation warrant, whether it is a permanent injunction or temporary injunction, or whether restoration of some rights, or whether as a student non-admission, whatever it is, any issue. So he must design it. Then no fact should be omitted as far as well. No facts. Let Mr. Ram Jethmalani time and again explain. I had a fortunate time to call him in my one of my seminars. He came in a court. I requested him. He immediately, very obediently, and he said in this, to all the legal community, never, never play with the facts. He said, fact is a fact. Now this is specs I'm wearing. Specs, it is seen, it is specs. That's all. Whether I can read or not, that is a different thing. Whether it is a short set, that's it. So Ramchandra clearly explained. Fact and tact is it. Fact is the truth, the which is seen in legal eyewitness. What he has seen, he has seen. But tact means with manipulation, presentation of which is not a fact. Okay. Like this, fact comes under primary evidence, tact comes under secondary. You need to prove it. Whoever makes anything, mind you, in pleading, if you plead something, the burden is on you to prove. In police cases, I'm not going, generally I'm speaking, because definitely said, but if I say something, if I say in writing something, it is my bounden duty to prove it. Then next point, and there are rules of the order of the drafting should be absolutely logical. Logical. What is logical? Please note. Logical means a contention, an environment which is easily understandable by even common man. I am not saying that. Courts. There was one Justice S.M. Dawood. You know, he wanted to actually fire the custom department, but the learned people, they say it very differently without hurting anybody. In the judgment, S.M. Dawood has said, I do not know the wisdom of the customs officers who have filed this affidavit in reply at length, and I do not understand the language they have put in commonly. I, as a common man, Justice Assam, I, as a common man, I understand that only simple English, which is interpreted as per Oxford Dictionary or Thusu Dictionary or simple language, as a prudent man understands. So, strictly logical means what is logical, what is illogical. So, logical means acceptable, conformable fact in issue, or it there is a that one thing is there in legal language, one terminology, fait accompli. Fait accompli means in simple sense, consequences follows automatically. So strictly logical. What is illogical? In contracted, you must have read in the first year itself or second, whenever it is contracted, the under citizen voidable agreement. A agreeing to bring the moon on earth. It is an impossible contract. So it is void of issue. Void. Voidable contract is now I say guarantee in this under earth within 40 meters I'll get you water. It is voidable because how do I say water may be there, may not be there. If not there, then what happens? So at least then what should I do? A surveyor is there. The surveyor, they put the meter. That meter they show how many feet approximately water can be, borewell can be put. So this is logic. Okay. So what you say, it should be logical. It should be appealable, acceptable. Then next point is in all forms of petition, in ours is a legal community, we must necessarily use forms of instruments and technical language should be employed. Technical language. Suppose if you are asking for bail, then the word in the prayer should be that this person accused may be released. Released word. This is technical release. So for example, in civil law, that forms of instrument, temporary instruments, temporary injunction, that you will say the defendant may be henceforth stop defaming me by either publishing or giving press notes or social media. Now the digital world has increased litigations a bit more. The social media, Twitter, this Instagram, WhatsApp, Facebook, all things are there. So he should be stopped from placing anything on record. There is that by there are 10 grounds in defamation. Speaking truth is not defamation. Setting a fact is not. So all this is what I mean to say. Forms of instrument should be in your mind. Formats. Forms means format, necessary format. Then second accept is technical language should be used as much as possible. Different technical as there are phenomena, there are number of books now. So online you can press and attempt, which we didn't have advantage at our time. We used to read books, only we used to read books and write and do it. But Now you have everything on touch of button. Synonymous words means if English the word says yes, in technical, in legal language, what? Legal language, yes, you cannot use. You will use the word acceptance. This. So language is same, but the words, then there are more technical logic, legal words, synonymous words. Legal books are also there. You can use as much as possible with covered with technological language, legal words will and in necessary format will make more appealable petition, application, suits, whatever it is. They more applicable and more acceptable by the all the courts, all the authorities. Because not only you will be fighting only cases are going to court. There may be instances where you write to the government, state government, local authorities, and other now services, authorities, so employers, employees, labor law, all these are there. So anything that it should be in an instrument of the format should be in a fixed format. It is available. There is one book called Dwivedi. He has written deeds and documents. Every format he has given. Every format. Every notice out should be a petition out should be formats. And there are also drafting and pleading. Various books are there with format. Now, which you don't have to buy it is available online. You can see all formats. Or the best thing is to go to a court, even if you are new, take a copy of it or write down the format. They did it. Best petition you take, and then prepare it. Then legal language. This is what I have been emphasizing. Legal language should be to the utmost possible extent precise and accurate. Don't try to say that I don't know. We are not, we are not, we are not trained to be precise. Simply, I am also part. I am not. We write same thing. We write instead of one para, 5 paragraphs. The central idea point is same. We are not precise because we want to keep on emphasizing to convince the honorable court or convince the local authorities, state authorities, central authority that this is the relief or this is the grievance and you please address it. So indication that then this any draft should be readily legible and should be in a simple language but legal terms, decorative legal terms. For the even your draft should be such, I'm telling you, not keep judges in mind or learned advocates who are double graduates. No, even a layman should be able to understand what you have written. That is the best drafting, but covered with legal. Last, I think uh, bell, I heard the bell, time is over. I'll just sum up within just 2 minutes. Then pleadings, what is the object? Two parties, dispute existence and adequate representation to be given. Then what is two parties should do? Fairness to law and presentation of adequate facts. And there are allegations, both sides, allegations on the other side. So the defense will array, then plaintiff, both will have intent, both have to place. As I told you, the principal concept law is same, only to bring before the court unvarnished truth, uncolored. Then second case is the function of pleading is not simply for the benefit of the parties and primarily for the assistance of a court defining with precision the area beyond which the court has to go. Beyond which, without the leave of the court and consequent amendment pleading, conflict must not be allowed to extend. So, pleading should be such that pleadings means what you want. Suppose, for example, A is denied passport, so they don't give reason. You keep on writing, and then litigant, then that person comes to you, sir, please go to the court and get me the passport. You apply, and you say you are Indian citizen, and you have all the document. You are entitled passport. You ask for passport order. So you precisely place that and plead that and get the order, and the person who is not being given passport will be given. Then fundamental rules of building, I'll end it within a minute. Facts, not law. Fundamental. Be very careful. That is why an advocate has to investigate first. What is client telling? How how far it is correct? How it is supported? आधार उधार होना चाहिए. वो जो भी बोलेंगे ऐसा नहीं, वो जो बोलो लिखने का नहीं ना. First you ensure. So facts, not law. Second is pleading of material facts. That should not overgo. And that is pleadings must be again time and then for the sake of repetition, tolerate me for repetition. Pleadings must be precise and concise, absolutely precise and come. Then amendment of pleadings are there. Then plaints everything. Coming to the conclusion, we all are absolutely fit to perform. Nobody is less, nobody is more. The entire law community requires hard work, sincere efforts, dedication. This profession is a devotion. Do the best. Last but not least, before I conclude the topic, and I'm open for questions, get the best drafts from the courts or from seniors and learn the art of drafting. Once you learn the art of drafting, once you plead properly, facts and law, nothing else is there, then definitely a person has to be successful. Case laws are only additional. Like case laws are nothing but calcium tablets, steroids. That's all. The once your facts and law within law you are preparing, case laws will further help you to get relief to that end and get success in your profession. Thank you, my dear friend, for patient listening.